Good morning, folks. As you can see, we're waiting on a few members. When I write my memoir of being chair of the Criminal Justice Committee, I will call it The Tyranny of the Tardy. And I'll dedicate it to this committee.
But I'll be here. Thanks.
I'm starting. Good morning. The Criminal Justice Committee will come to order. Would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Yeah. Lake effect and everything.
Is Carter?
He was
He's here.
Okay.
He's here. He stepped out for a moment.
Here.
Green. Young.
Here.
Arbit.
Here.
Devendorf.
Here.
Cerniglu. Here. Filler.
Yes.
Mueller.
Here.
Bezat,
Here.
Harris, Bagul.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the November 12th meeting. Without objection, the minutes are adopted. Just a reminder before we begin testimony today, anyone who would like to offer testimony needs to submit a white card to Melissa Sweet here. And so now we will, before we do our re-referrals, we're gonna start with testimony from Senators Polhanke and Bueno. Okay, thanks. Okay.
Or we use the same mic?
You can use the same.
Okay.
I'm gonna go there.
And you may start whenever you're ready.
Thank you, Chairwoman Hope, for giving me the opportunity to testify on my bill, Senate Bill 657. This bill was brought to me by the good people at Michigan Humane of Westland and the Humane Society of Huron Valley, who will testify after me. When animals are lawfully seized from an abusive or neglectful owner, the animals are held by animal control or a humane society. The Michigan legislature has a civil bond or forfeit process, but a problem has occurred, and that's when a civil bond or forfeiture process is tied to a criminal case. The result is often that animals can spend exceedingly long periods of time in an animal control setting while the criminal process plays out, with the taxpayer-funded animal control or the Humane Society footing the bill. My bill will repair this process by separating the civil process from the criminal process while still maintaining a defendant's due process rights. My bill ensures that a defendant in an animal cruelty or neglect case would be required to either post a cost of care bond or forfeit the animal to an animal control agency. We have added language requiring courts to take indigency into account when setting the amount of the bond. Here's a current real-life example of this problem. At the Humane Society of Huron Valley, this issue has resulted in 45 cruelty case animals currently in their care. Some have been in their shelter for nearly 4 years, including puppies who have grown up there. Together, these animals have received over 20,000 days of care on the Humane Society's dime. At roughly $45 a day for care, the Humane Society has incurred $900,000 in costs. In this time, the Humane Society could have helped at least 1,000 other animals. These bills passed the Michigan Senate in a big bipartisan way. It's good legislation, and I ask that you vote yes on moving it along to a House floor vote and a signature by the governor. Thank you.
Good morning, Madam Chair. My name is Bill Drake. Unfortunately, Senator Bueno is in committee right now, so he cannot be here to testify. But thank you very much for the opportunity to testify in support of these bills, 657 and 658. As Senator Polhanke testifies, these bills provide guidelines and accountability for animal owners when their animals are seized for neglect or abuse. Senator Bueno's bill, 658, amends the Michigan Penal Code to allow, not mandate, a court order for a defendant to pay certain costs when an animal is removed from an abusive or neglectful situation. And it also speeds up the timeline for an animal shelter to stabilize the animal and offer it up for adoption. Currently, animals can be required to live in a shelter for months or even years, as Senator Polhanke mentioned. We appreciate your consideration of these bills, and I know we have a number of people who wish to testify also. Thank you.
Thank you. We have Ann Griffin from Michigan Humane on Zoom. Thank you.
Good morning, Chairwoman Hope and members of the House Criminal Justice Committee.
Thank you for hearing Senate Bills 657 and 658 and for giving me this opportunity to testify in support. As you said, my name is Ann Griffin. I'm the Director of Advocacy for Michigan Humane, and I would like to thank Senators Polhanke and Bueno for sponsoring these bills. In addition to my testimony today, you have my written testimony, a letter of support signed by 15 stakeholder organizations in addition to Michigan Humane, and a support letter from Berrien County. As you know, legally, animals are property. However, unlike other types of property, animals are living creatures that are deserving of and receive special protection under Michigan's anti-cruelty and anti-neglect statutes. These bills are about how we manage the obvious practical problems that are presented when living animals are seized as evidence of a violation of the anti-cruelty or anti-neglect statutes, because clearly they cannot be handled like other types of evidence. So these amendments to the anti-cruelty and anti-neglect statutes would add a more effective bond or forfeit process to these statutes that would apply when an animal is seized and the animal's owner is charged with neglect or cruelty. These amendments are modeled on the bond or forfeit provision we added to Michigan's animal fighting statute, which passed with almost unanimous bipartisan approval in the 2017-2018 session. That statute is working very well and has prevented significant suffering. The purpose of a bond or forfeit process in the anti-cruelty and anti-neglect statutes is to provide seized animals with necessary care, ensure the costs of the care provided are appropriately allocated, and fairly resolve ownership of the animals. The current anti-neglect and anti-cruelty statutes do include a bond or forfeit process, as Senator Polhanke mentioned. Unfortunately, this current process is often unworkable, as it is a civil proceeding that is tied to the criminal case, which can create barriers to successfully completing the civil bond or forfeiture proceeding. So, for example, a defendant owner will often try to avoid prosecution, but under the current statute, some courts require the defendant owner's arraignment in the criminal case before the civil forfeiture case can proceed. Other delays in the criminal case can also make a cost of care bond or forfeiture effectively unavailable. And you heard Senator Polhanke testify about the impact of the problems with the current bond or forfeit process. When forfeiture or cost of care bonds are not available or are extremely delayed, despite the clear legislative intent that this not be the case, the holding agencies are responsible for paying for the seized animals' housing, food, veterinary care, and other costs, and the animals are subjected to long hold times. Under the proposed new bond or forfeit process, when a defendant owner's animal is seized in connection with a violation of the neglect or cruelty statute, either pursuant to a warrant or exigent circumstances, notice of the seizure and the defendant's options must be provided. And the defendant can do one of three things. First, the defendant can request a hearing to determine if the cost of the bond is fair and reasonable, if the seizure was legally justified, or both. Second, the defendant can pay the bond and retain ownership of the animals. Or third, the defendant can do nothing and the animals are forfeited to the seizing agency after 14 days. Finally, because an effective bond or forfeit process can remove a disincentive to pursuing these cases, it can result in the defendant getting the help he or she needs and ending the cycle of neglect or abuse against animals and even humans. As mental health issues are sometimes involved, the anti-neglect and anti-cruelty statutes currently allow a court to order a defendant to be evaluated and, if appropriate, ordered to obtain psychiatric or psychological counseling. In addition to abusing animals, the defendant may also be abusing humans, and removing the current disincentive to investigating these cases could result in identifying human abuse victims. We strongly believe that these changes to the anti-cruelty and anti-neglect statutes will have a significant positive impact for both people and animals in Michigan, and we respectfully request that you vote in support of this legislation. Thank you for your time and consideration.
Thank you. Next, we have Tanya Hilgendorf, President and CEO of Humane Society of Huron Valley.
Hi, thank you so much for having me chairperson in committee. We really appreciate you looking at this bill today. My name is Tanya Hilgendorf, and I'm the CEO of the Humane Society of Huron Valley, which is a no-kill shelter in Ann Arbor, serving roughly 25,000 animals a year. We strongly support this bill and think the question before you is a pretty simple one of fairness and justice. Should innocent victims of animal cruelty be essentially imprisoned in shelters for months or years while the people who hurt them walk free? We at HSHV investigate about 500 cases of animal cruelty a year, with only the most egregious cases approved for prosecution. That includes when people are found guilty, those punishments rarely amount to more than a slap on the wrist. However, for the animals, we could at least turn their tragedies into happy endings very quickly if it weren't for a painfully slow criminal justice system that in our county requires our animals to wait 2, 3, or more years to be released for adoption. A quarter, sometimes half of their lives. Shelters are not designed for long-term care. They are short-term facilities. They are not sanctuaries. Long-term sheltering, where an animal spends most of their day caged, can be extremely and permanently damaging, both physically and mentally. At the end of their stay, sometimes animals are no longer adoptable. This is a tragedy. In some shelters, I know that their cruelty case animals are not even walked. Dogs sit in cages 24 hours a day. This is what we might consider for humans solitary confinement, a level of punishment we reserve for our most violent human offenders, with sentences that would equal 15 or 20 years for people. As the good Senator Paul Hankey testified, we've had dozens of cruelty cases stuck in our care for years and spending nearly $1 million. Costs that we will never recover because even when restitution is ordered, it is rarely ever paid. In place of those 45 animals she talked about, for the same length of time, we could have helped 1,000 other animals. Obviously, this is a vast waste of community resources, taxpayer money, and is tragic for the victims themselves and all the other animals who cannot be helped. You may have before you a picture of a little dog named Moo. Moo is a 10-pound senior Papillon who has been in our care for 2.5 years. 2.5 years. She was witnessed being beaten and kicked by her owner, an owner with a long list of other criminal charges, as is often the case. Yet Moo still waits for a permanent home simply because her abuser never shows up to court. So like so many, her freedom is taken away while the abuser walks free. We recently had a dog who had been with us for over 3 years while the person who committed cruelty against that dog went through the system. Finally, the dog was released to us. The owner was found guilty of animal cruelty and fined $50. So that dog sat in a shelter for 3 years, and the person who beat and neglected the dog got a $50 fine. So we know many prosecutors, including our own, will not use the current forfeiture process. It is too confusing, and our overwhelmed offices don't have time to learn it and apply it. And animals, frankly, always fall to the bottom of the list in stress systems designed for humans. Another really important point, and you may know this, is that Michigan shelters are all overcrowded and overstressed. COVID, the economy, our veterinary shortage are crushing shelters throughout the state. At HSHV, we have a long list of animals waiting for help. Statewide, euthanasia in shelters is rising. We cannot afford to needlessly hold animals that could be in loving homes. This bill could have an immediate impact on the lives of homeless and abused animals and provide an important form of relief that shelters so desperately need. So thank you so much for your time and consideration, and I do so much hope you will vote yes. Thank you.
Thank you. We do have, do we have anyone else who'd like to speak? I don't think we do. I'm going to refer the cards to the clerk here, and they will be part of the minutes. We are in somewhat of a time crunch this morning, so I'm going to hold the vote until after we take testimony on some other items. Next, we will hear testimony on House Bills 4431, 4432, 4433. Rep. Arbit?
Good morning, Chair Hope, Vice Chair Andrews, Vice Chair Filler, and colleagues. Like much of what we debate in Criminal Justice Committee, House Bills 4431 to 33 pertain to sensitive topics. So I ask for your grace this morning as I touch on some sensitive and mature matters that might be uncomfortable to some people. Nevertheless, they are important issues, and I hope we will be able to confront them as adults with the seriousness that they deserve.
May I just give pause right there for a second, because there are some little kids here. Yeah, and that's up to who's ever in charge of the little kids. Please continue, Rep. Arbit.
Thank you. This legislation, which I have introduced alongside Representatives Reingans and Devendorf, would finally repeal Michigan's unconstitutional ban on, quote, the abominable and detestable crime against nature. What is the abominable and detestable crime against nature, you may ask? This legal term of art, which dates back to the 16th century British common law, was incorporated into colonial law and American state laws, includes masturbation, oral sex, either between a man and a woman or two men, anal sex, either between a man and a woman or two men, and bestiality. Generally, it pertains to any sex act that is not intended to or cannot result in procreation. Yikes! I would guess that 99% of adult Michiganders are guilty of this crime. Historically, these laws were utilized primarily to prosecute adult men who had any form of sexual intercourse with other adult men. In 2003, just 21 years ago, the United States Supreme Court ruled in Lawrence v. Texas that these state laws criminalizing intimate relations between two consenting adults of the same sex violate the 14th Amendment to the United States Constitution. Despite repeated attempts to do so, the legislature has never repealed Michigan's so-called sodomy ban, permitting a zombie law that insults the constitutional rights of Michiganders to remain on our books. That's why Representatives Devendorf, Reingans, and myself introduced House Bills 4431 to 33 to finally strike this unconstitutional law from statute, as all but 7 other states have done. Importantly, the current law is written in such a way that intimate acts between consenting adults of any sex, straight or gay, may engage in, including those that I have described above and honestly just do not care to repeat, carry the same criminal penalty as the act of bestiality. All of these acts are punishable by 15 years in prison or up to life in prison for, quote, sexually delinquent individuals. This is why this legislation is not a straight repeal bill. In seeking to strike the deprecated portions of the sodomy law, it was essential to retain the portion of the statute that criminalizes bestiality. So we removed the arcane language referencing crime against nature and substituted it with the term bestiality, ensuring that this heinous crime remains illegal in the state of Michigan. This legislature has rightfully worked diligently over the past 2 years to slay many zombie laws rendered unconstitutional by the Supreme Court or nullified by the people of this state. It is vital that we continue this work to eliminate laws that would leave Michiganders' rights unprotected in the event of adverse changes in the federal legal landscape. Some will ask, why now? Why must we repeal this law if the Supreme Court rendered it null and void 21 years ago? And no Michigan prosecutor, at least to my knowledge, has expressed desire or willingness to issue charges under it, even if they could. Well, I don't want to play coy. The Supreme Court's decision in Dobbs v. Jackson overturning the 50-year precedent of Roe v. Wade has made vulnerable all other federal rights promulgated by the court on the principle of substantive due process, a heretofore mainstream reading of the 14th Amendment that accepts a capacious definition of Americans' rights to privacy under the Constitution, which neither the federal government or the states may abridge. In Dobbs, the Supreme Court began to pull at the threads of these substantive due process rights to privacy, squarely training in their sights on the right to access contraception, Griswold v. Connecticut, the right to marry for same-sex couples, Obergefell v. Hodges, and the right to engage in consensual adult intimacy, Lawrence v. Texas. Indeed, in his concurring opinion in Dobbs v. Jackson, Justice Thomas wrote, in future cases, we should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, because any substantive due process decision is demonstrably erroneous. We have a duty to correct the error established in those precedents. I believe Justice Thomas is sincere in his desire to recriminalize these intimate acts, and he is not alone. The assault on these rights is clear, motivated in part by an intense religious bigotry against gay people in particular, as even just yesterday, one of our own colleagues in the State House declared his desire to see same-sex marriage outlawed once again, calling it uncontroversial and not extreme. Personally, I think the idea of ripping apart loving families is extreme, just as I think the idea of the state being empowered by statute to arrest private adult citizens for engaging in consensual sex acts of their choosing is extreme. It is anyone's guess whether the Supreme Court will follow Justice Thomas's lead, but should the court one day soon have a majority inclined to overturn Lawrence v. Texas, it is imperative that Michigan does not have a criminal ban on the books that could be used to target and criminalize people across Michigan. Because the moment Lawrence is overturned, this statute is once again good law, and any individual engaging in this conduct could theoretically be arrested and charged. Passing these bills, therefore, constitutes an emergency for all freedom-loving Michiganders and all Michiganders who oppose the intrusion of the government into our private lives, which I assume is most of us, whether we are gay or straight, Democrat or Republican. I urge the entire committee to unanimously and uncontroversially send this package to the House floor to codify Lawrence v. Texas in the state of Michigan. I welcome any questions from the committee. Thank you, Madam Chair.
I see no questions. Thank you. And we will hold this vote until the end as well, because we do have another topic that we'd like to get to today. House Bill 5828 from Representative Young. And if you have someone you'd like to call up with you at this time, please feel free.
All right. Well, good morning, Chair Hope, Vice Chair Andrews, Minority Vice Chair Filler, and to the members of the committee. Thank you all for allowing me to speak to my bill today, House Bill 5828. This bill is something that is really near and dear to my heart. I have not just a constituent, not just a resident of Detroit, but actually a sister and a friend who brought this bill before me. The intent of this bill is for the Department of Corrections to clarify and explain the difference between medical release of information and emergency contact, and why both are important, and for them to make more contact with inmates about filling them out and keeping these documents current. I'm really thankful for the participation of MDOC. They worked with us hand in hand in making certain that we got this legislation where it needed to be on this morning. Under my bill, when a prisoner arrives at a correctional facility, they will be provided with a medical release form and an emergency contact form. These tools empower incarcerated individuals to designate emergency contacts and authorize the release of qualified medical information to trusted individuals. For those already in custody, the same resources will be made available. Families and loved ones deserve to know when a critical medical emergency occurs where a prisoner is receiving treatment when it's appropriate. This bill also streamlines the process for the release of information if someone is in a hospital, ensuring that even in those moments of crisis, compassion and connection remain possible, subject to safety considerations. Importantly, this legislation does not compromise security or operational efficiency, and that's really, really important. It does not compromise security. This bill provides clear guidelines for updating contact information and distinguishes between authorized recipients of medical information and emergency contacts. The Department of Corrections will also need to develop and provide inmates with a brochure, which they've agreed to do, with a brochure to explain these designations, ensuring clarity for everyone involved. House Bill 5828 will align with our shared values for fairness, accountability, and the humane treatment for all individuals, including those in our correctional system. It is not only a step toward better policy, but also a step for a more compassionate society. And so with that, Madam Chair, I would like to turn the mic over to my friend and sister, Dr. Tara Defoe, to share her testimony.
Good morning, Chair Hope and Vice Chair and committee members. My name is Tara Defoe. I'm the mother of Emilio Defoe, who passed away on October 3rd, 2014, at the age of 24 when he was incarcerated at Lakeland Correctional Facility. I would like to say thank you to Representative Stephanie Young and to the chair for your support in introducing House Bill 5828. As a former staffer to both House and Senate, I understand the many challenges you may face when asked to support a bill. This morning, I am asking you to support your support on House Bill 5828, which will allow the medical information to be released to family member or a designated emergency contact to disclose the location at which a prisoner is receiving medical treatment during a critical medical emergency and to allow approved visitors. Please allow me to share why I sit here before you today. On September 29th, 2014, I received a call from my son, which ended with "Ma, I love you." On September 30th, I received a call from Lakeland that my son was rushed to the hospital, but the correctional officer refused to provide any details. What I experienced moving forward was a mother's worst nightmare. Waiting anxiously, I received another call from a different correctional officer who informed me that my son was transported to University of Michigan Hospital in Ann Arbor and was being prepared for emergency surgery. When my daughter and I arrived to the hospital, we were told that we would have to wait and remain in the emergency room as we weren't allowed to go to the site of the hospital where he was located. After 3 hours, the hospital social worker informed me that she was not able to provide me any information as she was not authorized to do so, and that we should remain in the emergency room, waiting room. After making countless phone calls, I finally spoke to former Senator Virgil Smith and former Senator Burt Johnson. To provide them with the little information that I was given, I also spoke with the former Deputy Mayor of Detroit, who was my immediate supervisor at the time. Early Wednesday morning, October 1st, I received a call from the member of the mayor's office, which provided a timeline that landed my son in emergency surgery. It was clear that the only reason I was able to obtain information regarding my son's health condition was because of the high-level individuals at my reach. The caller informed me that my son collapsed after breakfast and was transported in a non-emergency correctional vehicle to Jackson Community Hospital. Emilio then was transported by EMS who performed 37 minutes of chest compressions, arriving to U of M where 10-hour heart surgery was in progress. During the next hospital shift, my family and I were asked to leave the emergency room and gather in the main hospital lobby. When we arrived to the lobby, I was curious to see if the receptionist would allow me information on my son, and to my surprise, she did. I eagerly rushed in hopes of seeing my son and was greeted by correctional officers and hospital staff that I was not allowed to see my son as the warden had not provided permission. In frustration, I informed them that I had been there all night waiting for my son and getting information, only to be turned away again. After leaving the hospital and arriving home, I received a call from the doctor who stated that the warden had authorized him to provide update on my son's condition. Then he informed me that the warden had authorized me to see my son. He stated that the correctional personnel from the prison were bringing a paper pass that I would need to present to the correctional officers on duty. When I returned to the hospital and saw my son for the first time, it was the worst scene that a mother could experience. My son was connected to countless machines and medication dispensaries. Over the next 2 days, things took a turn for the worse. I had to drive from downriver to White Lake Correctional Facility to obtain a paper pass that looked like it was typed on a typewriter older than me, to give to a correctional officer at the hospital to see my son. Again, I had to do this for 2 days. Because of the senators, I was able to text the warden from Lakeland, who then texted the warden from White Lake to authorize a visitation from my daughter, my son's daughter, and our family clergy leaders to pray. Doctors informed me that Emilio took a turn through the night and it was just a matter of time. On Thursday, October 2nd, I received a call received a call that Emilio wasn't showing any more signs of life while I was walking out of White Lake Correctional Facility picking up my paper pass. At that time, could have been spent by my son's bedside, but it was spent picking up a piece of paper to take to the hospital, something that could have been faxed or emailed. After doctors reviewed his results, I was informed that they would officially call his date of death the following day. Emilio had too much bleeding on his brain. Again, my family and I had to leave the hospital as I was not allowed to stay after 7 p.m. by his bedside. My family and I walked away in disbelief that this is how families were treated during critical moments. The doctors officially called Emilio's date of death the morning of October 3rd, 2014. Because my son was a registered organ donor since the age of 18, his transplant surgery took place on October 4th. While preparing for the surgery, transplant doctors were horrified that the correctional officers were still standing bedside while attempting to enter the prep area. Emilio was a father, he was a son, he was a brother, a friend to many. Unfortunately, his lack of mental health support as a young adult landed him in the hands of Michigan Department of Corrections. Emilio served as a district manager to former Senator Virgil Smith Jr. Emilio was a member of St. John the Great Baptist Church under the leadership of Bishop Victor Sharp. While incarcerated, Emilio attended church services, educational classes, and work study, and even participated in the emotional support dog training program. He never tried to deny his wrongs, but he was fighting to make things right. My goal is to change these outdated policies through House Bill 5828. What I experienced, no family should have to endure. During this entire time, from being transported from the prison to both hospitals, my son was chained to the bed from his hands and waist. I pray and I request that you, in turn, please support this bill by voting yes. Thank you.
Thank you, and I'm sorry for your loss.
Thank you.
We have Kyle Kaminsky, who would like to speak on this bill. And looking for Trudy Williams, if she is here. You may come forward.
Good morning, Kyle Kaminsky from the Michigan Department of Corrections, and I will keep my comments brief, but thank you to the committee chair and the committee. I did want to recognize the sponsor, Rep. Young, who very courteously worked with the department, was willing to take our feedback on various elements of this. We are ultimately at this time neutral on the bill because we think that it really reflects a lot of the current practice. Some concerns were raised, some very legitimate concerns were raised by Ms. Defoe, and I think it's, I'm kind of obligated just to provide an update. Things like the requirement to get a paper pass to go to a hospital to see a loved one, that was discontinued many years ago. All of that is handled now via cell phone between the facilities, so families, once approved, can go directly to the hospital to see their loved one. Likewise, we really stress the need for medical releases and emergency contacts. Since the bill was introduced, we actually improved our main medical release form. So the old release expired after 1 year, which created a lot of challenges. People would think they had a valid release, but in fact, when an emergency happened, it was no longer valid. We were really pleased that as of July individuals can now sign a verbal medical release that lasts for the entirety of their incarceration term, so that there's not that risk of expiration. Finally, as part of the budget process, we worked with the House subcommittee as well as the Senate subcommittee and agreed to the brochure that was mentioned earlier. And so we do think that informing people of the importance of these two things is a very important thing. So we appreciate the sponsor also bringing that to light. And with that, I'm happy to take any questions.
Thank you, Ms. Williams.
Oops. Thank you. Good morning, Madam Chair and committee members. My name is Trudy Williams, and I'm grateful for the opportunity to speak this morning. I am currently employed with Teen Wellness Center. I'm a director there, and I'm also a member of the Family Advisory Board to the Michigan Department of Corrections, where I work very closely with Mr. Kaminsky. And whereas the policy is present and the form is present to update family members, it's not enough. Unfortunately, there are families that contact the Family Advisory Board to request information regarding their loved one. If that person is ill, would they be notified? So the information is not being communicated enough. There is a start, but it's not done enough. When a person enters into the Michigan Department of Corrections, families should be notified. They must be notified. That is a gift that I think any family member that is present here today or that exists would want to know. If there's a family member in crisis, to be notified. To be notified. I believe that is a human right and human dignity. I thank you for the opportunity to be able to speak. Please vote yes on this bill. It's needed. As I stated before, we work closely with Mr. Kaminsky, but it's not enough. This needs to be communicated more to families. It needs to be communicated more to individuals who are in the custody of the Department of Corrections. And I thank you for this opportunity.
Thank you. I don't see any questions. Thank you all for your testimony. Appreciate it.
Thank you.
Thank you.
No. And again, with the cards of support and opposition, the clerk has those and they will be made part of the minutes. Okay. We're going to start voting. First, I need a motion to re-refer Senate Bill 813 to the Judiciary Committee. Senator, excuse me, I just promoted you. Rep. Carter. Rep. Carter moves. Would the clerk please call the vote?
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris, Bagol,
Yes.
Chair Hope.
Yes.
Madam Chair, you have 11 yeas, 0 nays, 0 pass. Senate Bill 813 is referred to the Committee on Judiciary.
Thank you. I'll take a motion from Representative Young to refer House Bill 6015 to the Committee on Local Government and Municipal Finance. Would the clerk please take the roll?
Representatives Andrews,
Yes.
Carter,
Yes.
Breen, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris, Bagol,
Yes.
Chair Hope.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
I'll take a motion from Representative Arbit to refer House Bill 6016 to the Committee on Local Government and Municipal Finance. Would the clerk please take the roll?
Representatives Andrews,
Yes.
Carter,
Yes.
Green, Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
Yes.
Mueller,
Yes.
Bazat,
Yes.
Harris, Bagol,
Yes.
Chair Hope.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
I'll take a motion from Representative Devendorf to refer House Bill 6017 to the Committee on Local Government and Municipal Finance. Madam Clerk, please call the roll.
Representatives Andrews.
Yes.
Carter.
Yes.
Green. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris. Bagol.
Yes.
Madam Chair,
Yes.
you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. Going back to the items that we heard today, I will take a motion to adopt the H1 sub for Senate Bill 657. That was the animal forfeiture testimony that we heard just a few minutes ago. Representative Cerniglu moves. Would the clerk please call the vote?
To adopt the substitute H1 to Senate Bill 657, Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris. Bagol.
Yes.
Madam Chair,
Yes.
you have 12 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you. I'll take a motion from Representative Andrews to report Senate Bill 657 with recommendation as substitute H1. Madam Clerk, please call the vote.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris. Bagol.
Yes.
Chair Hope.
Yes.
Madam Chair, you have 12 yeas, 0 nays, and 0 pass. Senate Bill 657 is reported with recommendation as substitute H1.
Thank you. I will take a motion from Representative Carter to adopt the H1 sub for Senate Bill 658. Madam Clerk, please call the vote.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris. Bagol.
Yes.
Madam Chair,
Yes.
you have 12 yeas, 0 nays, and 0 pass. The substitute is adopted.
Thank you. I'll take a motion from Representative Breen to report House Bill 658 with recommendation, oh, excuse me, I misspoke. Senate Bill 658 with recommendation as substitute H1. Madam Clerk?
Representatives Andrews.
Yes.
Carter.
Yes.
Green.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris. Bagol.
Yes.
Chair Hope.
Yes.
You have 12 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. I will take a motion from Representative Arbit to report House Bill 4431. That's the sodomy bill. And Madam Clerk, please call the vote.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 2 nays, 2 pass. House Bill 4431 is reported with recommendation.
Thank you. I'll take a motion from Representative Devendorf to adopt the H2 substitute for House Bill 4433. Madam Clerk?
Who made the motion?
Representative Devendorf?
To adopt the H2 substitute to House Bill 4433, Representative Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair, to
Yes.
adopt the sub. You have 8 yeas, 2 nays, 2 pass. The substitute is adopted.
Thank you, Madam Clerk. I need to go at ease at the call of the chair. Okay, we're back on the record. I'll take a motion from Representative Cerniglu to report House Bill 4432 with recommendation. Madam Clerk, please call the vote. Okay, a little technical glitch here. I'm going to return to House Bill 4433, which has an H2 substitute, and I'll take a motion from Representative Cerniglu to adopt the to report HB 4433 with recommendation as substitute H2. Madam Clerk.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
No.
Harris. Bagol.
No.
Chair Hope.
Yes.
You have 8 yeas, 2 nays, 2 pass. House Bill 4433 is reported with recommendation as substitute H2.
Thank you. Now I will take a motion from Representative, I don't remember where I was in my, Devendorf or Andrews? Okay. I'm sorry. I try to rotate to keep it all fair. I'll take a motion from Representative Andrews to report House Bill HB 4432 with recommendation.
Representative Andrews.
Yes.
Carter.
Yes.
Breen. Aye. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair.
Yes.
You have 8 yeas, 2 nays, 2 pass. House Bill 4432 is reported with recommendation.
Thank you. I will now take a motion from Representative Young to report House Bill 5828 with recommendation. Madam Clerk?
Representative Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Pass.
Mueller.
Pass.
Bazat.
No.
Harris. Bagol.
Pass.
Madam Chair.
Yes.
You have 8 yeas, 1 nay, 3 pass. House Bill 5828 is reported with recommendation.
Thank you. And now turning back to some items that we heard previously in this term, House Bill 4160, 4161, 4162, 4163, 4164. We heard these bills on May 9th, 2023, and we do have a sub which would change the time frame from 10 years to 20 years before an individual could be considered for parole. It adds first degree CSC to the list of offenses, and make a couple other technical clarifications, as well as adding some factors for consideration. As you'll recall, Michigan has more individuals serving a juvenile life without parole sentence than any other state in the nation. 74% of the folks who are awaiting resentencing are Black, which is one of the worst racial disparities of its kind in the country. Research shows, and we heard this during testimony, that youths incarcerated for longer than 15 to 20 years has no impact on public safety. And 27 states and the District of Columbia have already banned the use of juvenile life without parole, while 7 other states have no one serving the sentence. And before we vote, we will go at ease. We're going to return to the record just because we do have a number of things to get through here. I'll take a motion to adopt the H5 substitute for House Bill 4160 from Representative Carter. Please call the vote.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
I'll return to Representative Breen to adopt the H5 sub for 4160.
Aye.
Representatives Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair.
Yes.
You have 8 yeas, 4 nays, 0 pass. The substitute is adopted.
Thank you. I'll take a motion from Representative Young to report House Bill 4160 with recommendation as substitute H5. Madam Clerk?
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair.
Yes.
You have 8 yeas, 4 nays, 0 pass. House Bill 4160 is reported with recommendation as substitute H5.
Thank you. I'll take a motion from Representative Devendorf to adopt the H2 substitute for House Bill 4161. Madam Clerk, please call the vote.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair.
Yes.
You have 8 yeas, 4 nays, and 0 pass. The substitute is adopted.
I'll take a motion from Representative Cerniglu to report House Bill 4161 with recommendation as substitute H2. Madam Clerk?
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young.
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. The motion prevails.
Say that again?
4161, the motion prevails.
Oh, prevails, okay. Prevails can sound like fails sometimes.
Oh, no.
It was prevails. I'll take a motion from Representative Andrews to adopt the H3 substitute for House Bill 4162. Madam Clerk?
It was Rep. Andrews.
Rep. Andrews?
Okay. Representative Andrews,
Yes.
Carter,
Yes.
Breen.
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. The substitute is adopted.
I will take a motion from Representative Carter to report House Bill 4162 with recommendation as substitute H3. Madam Clerk?
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Bagol.
No.
Chair Hope.
Yes.
Madam Chair, you have 8 yeas, 4 nays, 0 pass. The motion prevails.
Thank you. And I will take a motion from Representative Young to report HB 4163 with recommendation. Would the clerk please call the vote?
Representative Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. House Bill 4163 is reported with recommendation.
Thank you. I will take a motion from Representative Devendorf to report HB 4164 with recommendation. Madam Clerk, please call the vote.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen,
Aye.
Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. House Bill 4164 is reported with recommendation.
Thank you. We will again go at ease with the call of the chair. When you were chair of judiciary, we did this exact. We are back on the record and taking up another bill package that we heard very, very long ago on March 19th of this year, the second look package. We will have a vote on House Bills 4556, 4557, 4558, 4559, 4560. Again, the sponsors have worked extensively with stakeholders, and they have changed the amount of time for a petition from 10 years to 20 years. So that means that a person would be able to apply for parole consideration after 20 years if, excuse me, I just misspoke. They will be able to apply for resentencing after 20 years in the judge's discretion. There are a number of exclusions here, including terrorism, including sex offenses, including some domestic violence. There are some other technical changes, and we're gonna vote.
All right, could you go at these so I can talk to the committee about?
Sure. You have about Okay, we are back on the record. I'll take a motion from Representative Andrews to adopt the H1 substitute for 4556. Madam Clerk?
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. The substitute is adopted.
I will take a motion from Representative Carter to report House Bill 4556 with recommendation as substitute H1. Madam Clerk, please call the vote.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. House Bill 4556 is reported with recommendation as substitute H1.
Thank you. Could you please silence your phone?
Yeah, I'm trying.
Okay. I will take a motion now from Representative Young to adopt the H2 substitute for House Bill 4557. Madam Clerk?
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. The substitute is adopted.
Thank you. I'll take a motion from Representative Devendorf to report House Bill 4557 with recommendation as substitute H2. Madam Clerk?
Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. The motion prevails.
Thank you. I will take a motion from Representative Cerniglu to report HB 4558 with recommendation. Correct. 4558.
Okay, and who made the motion?
Representative Cerniglu made the motion.
To report House Bill 4558 with recommendation, Representatives Andrews.
Yes.
Carter.
Yes.
Breen.
Aye.
Young.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
No.
Mueller.
No.
Bazat.
No.
Harris. Pagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. House Bill 4558 is reported with recommendation.
Thank you. I'll take a motion from Representative Andrews to report HB 4559 with recommendation. Madam Clerk?
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Pagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. House Bill 4559 is reported with recommendation.
Thank you. I will take a motion from Representative Carter to report HB 4560 with recommendation. Madam Clerk, please call the vote.
Representatives Andrews,
Yes.
Carter,
Yes.
Breen. Aye. Young,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Cerniglu,
Yes.
Filler,
No.
Mueller,
No.
Bazat,
No.
Harris, Bagol.
No.
Madam Chair,
Yes.
you have 8 yeas, 4 nays, 0 pass. House Bill 4560 is reported with recommendation.
Thank you. And just to clarify again, the bill package that we just voted on is referred to as the second look bill package. It allows someone to apply for resentencing, not parole, after 20 years. I just want to make sure that was abundantly clear. Representative Breen moves to excuse absent members.
Yes.
Briefly, Representative Filler.
Chair, not only were the bills not on the committee calendar, but the subs were provided to the members 2 minutes before vote. And so clearly we disagree with the legislation, but we disagree with the process too. So thank you.
Thank you. Representative Young moves to excuse absent members. There being no objection, the motion prevails by unanimous consent. There being no further business before the committee will stand adjourned.